We all know gender identity and sexual orientation issues have really become an increasingly visible part of the social landscape. We've seen Caitlyn Jenner, we've seen the DOJ battle with North Carolina, and although the Equality Act of 2015 is still in Congress, and I'll note, interestingly enough, it's had more than 200 original co-sponsors, which was the most congressional support that any piece of pro-LGBT legislation has received, it's still stuck in Congress. And so the agencies have been pretty proactive in this area. And I think in 2015, part of that is spurred by the fact that the EOC received a total of 1,412 charges that included allegations of sex discrimination related to sexual orientation or gender identity and transgender status, neither of which is protected expressly under Title VII. That said, the EOC came in like a lion in 2015, and in Baldwin versus the Department of Transportation, held that a claim of discrimination on the basis of sexual orientation necessarily states a claim of discrimination on the basis of sex under Title VII. And looking back to a 2012 decision, which was Macy V. Holder, the commission held that intentional discrimination against a transgender individual because of that person's gender identity is by definition discrimination based on sex. And so the Lusardi Commission took that and said that an employer's restrictions on a transgender woman's ability to use a common female restroom facility constitutes disparate treatment, and that intentional misuse of a gender employee's new name and pronoun can also constitute sex-based discrimination and/or harassment. Given all of the media coverage we've seen, it shouldn't be surprising that other agencies have also waded in. In April 2015, the Department of Labor announced that federal contractors who were subject to Executive Order 11246, which established requirements in 1965 for non-discriminatory practices in hiring and employment on the part of government contractors, that they must allow transgender employees to use restrooms and other facilities consistent with gender identity. A number of agencies have also issued statements reflecting similar opinions. I mentioned DOJ recently, but I also want to note that OSHA issued a June 1, 2015 publication, a guide to restroom access for transgender workers, and the Office of Personnel Management in 2015 also issued guidance regarding the employment of transgender individuals in the federal workplace, making clear that as the nation's largest employer, the federal government should set an example for other employers that employment discrimination based on sexual orientation or gender identity is simply not acceptable.